Take two. I call this meeting of the Texas Board of Veterinary Medical Examiners to order at 9:01 a.m. The mission of the Texas State Board of Veterinary Medical Examiners is to establish and enforce policies to ensure the best quality of veterinary and equine dental provider services for the people of the state of Texas. Mrs. Whitehead, would you please call the roll?
Dr. Gola,
Here.
Dr. Kreiner,
Here.
Victoria Whitehead here, Dr. Skaggs,
Here.
Sue Allen,
Here.
Keith Pardue,
Here.
Raquel Olivier, absent. We anticipate her to come online though.
We will announce her when she arrives. Okay, next is consideration and approval of the October 17th, 2023 minutes. Is there a motion to approve the minutes from October the 17th board meeting?
Move.
Second.
Any discussion? Hearing none. All in favor, please vote aye.
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 Any opposed? Motion carries. We accept the minutes. Okay, item number 3 on our agenda this morning, we're going to start with our public comments. And when we do that, first of all, thank you all for being here to publicly comment to us with your concerns and opinions. We do very much appreciate that. Our process for this morning is that we're going to start with those that are online if she's available. Anya, is she available?
She is.
Okay.
Moved her back.
And with that, we are going to limit public comments to 3 minutes. I will start the timer just so that there's clarity for that. And when the timer goes off, you'll know that your 3 minutes is up. If you haven't finished, just wrap it up as quickly as you can. Okay? So with that, our first public comment will be, oh, thank you. I've just been notified that Raquel Olivier has joined us online as our board member. Thank you for that. Okay, first public comment will be online from Miss Jody Ware.
Good morning. Thank you for the opportunity to speak. In 2009, a well-known orthopedic surgeon at Texas A&M University concocted a new type of cruciate surgery called CBLO. It involved cutting a dog's shin bone with a power saw, altering the architecture, and putting it back together with a plate and screws. By the surgeon's own admission to a colleague, CBLO was a much more unstable osteotomy than conventionally used TPLO due to the differential bone cut. It therefore required differential implants. But rather than research and develop his new procedure at A&M, where in theory research protections should have been in place, he retired and continued to work there on a part-time contract basis with his principal place of employment in private specialty practice. He engaged a few other vets in Texas, and they carried out CBLO experimentation on private practice patients where lawful research protections are wholly lacking. This was where my dog Lightning and I unwittingly entered the scene. We consulted with a leading specialty practice in Houston that purported to perform more cruciate surgeries than anywhere else in the country. So I thought we were in good hands, especially given the surgeon told me that he would use a minimally invasive arthroscopic cruciate repair that he averaged 15 times per week. Instead, Lightning was one of the early victims of CBLO. He was used as a study subject without my knowledge or permission and suffered avoidable harms that led to his early death. It took me years to sort and report for a few reasons. We stopped seeing the surgeon due to challenges in communicating complications. Naively, we transitioned Lightning's care to none other than A&M. And few knew what CBLO was. Even A&M was confused, or covering up, by referring to Lightning's historical right TPLO. Not to mention the involved surgeons eventually presented and published on CBLO as if the investigations took place at A&M. New and different evidence emerged over the years, and others I approached continually reminded me that the state board was the sole regulatory authority. So I filed new and different complaints against the surgeon of record. None of those complaints were handled appropriately, and none were memorialized properly in the public record. The board's aiding and abetting and longstanding concealment are mighty convenient for the licensee and a real concern as his patient care, teaching, and research expand in Texas and beyond. Last week, the board's new general counsel informed me that an informal staff conference for my latest complaint would be scheduled soon. Given the past preferential treatment of this licensee, I sought assurances from her that the same manipulation of statute would not occur as did with my 2019 complaint, allowing him a second IC. But I got the same song and dance saying he would be permitted a second IC if he so chose. I therefore withdraw my complaint. I will not continue to be a party to the games this board plays. Enough is enough.
Thank you, Ms. Ware. Appreciate your comments. Okay, having no more
Thank you.
comments online, correct? Okay, we'll call up our first here in order, and that would be Ms. Jody Long.
Good morning, Board. My name is Dr. Jody Long. I'm the current president of the Texas Veterinary Medical Association, and I have a brief statement prepared. As you are all aware, in last session, the legislature passed SB 1414, which temporarily attached the Texas Board of Veterinary Medical Examiners to TDLR to help the agency deal with issues such as acquiring a new database to manage licensee information. While TDLR is providing TBVME with needed administrative support, TVMA understands that the TBVME will have to raise licensing fees substantially to cover the costs associated with implementing a new database, among other agency reforms. This is not aligned with the stated intention of lawmakers when SB 1414 was passed. Before and during the 2023 legislative session, there was much talk and fanfare about our state's unprecedented $32 billion budget surplus. And stakeholders were assured multiple times during the session by LBB, TDLR, and Sunset staff that no major fee increase would be necessary to accomplish the desired reforms. At this point, it seems the professionals licensed by TBVME have been punished for what the state was unable to do. This is despite the fact that, even at the current levels, individuals licensed by this agency already pay more in fees than it costs to operate it. It is unconscionable that during a time of unprecedented prosperity, it should necessitate an additional 74% fee increase to accomplish the state's business as it relates to this agency. In the case of LVTs, many of whom earn modest wages by most other industry comparisons, they now see an increase of 60%. All of these costs will ultimately raise the cost of animal care in this state and are tantamount to a tax on the veterinary professionals and taxes. The agency must do a better job of communicating its budgetary needs to the LBB's process so that the legislature can evaluate exceptional item merit and not thrust them onto the backs of the profession. Thank you.
Thank you, Ms. Long. Okay, next up will be Ms. Heather Katiba.
Good morning.
Good morning.
My name is Heather Katiba. I'm here to address this board. Thank you for the opportunity. Since 1911, the Texas Board of Veterinary Medicine has been in effect. At the helm, presiding officer of licensee status designated by the governor, specifically to ensure that professional medical regulation is handled by somebody qualified. Chairman, board members, there are 2 cases pending before you for sanctions involving Ashley Watts DVM. I ask that you consider enforcing the full weight of the law. In multiple legal proceedings, this licensee has been described as cruel, negligent, dishonest, felonious, has displayed corruption, cruelty, torture within the commission of a felony offense connected to and with the practice of veterinary medicine. Surely this is not beginning or the start of how we want our licensees to practice. Ashley Watts has undermined the role of professional licensing, the preservation of public trust, and the obligation towards patient welfare, as if all of these factors were an inconvenient responsibility. Regulation at times can offer a second chance. I have been here before. It was made clear to me by this licensee in a court of law that she had no intention of being accountable or responsible for her actions or harms. This was not a surprise. When someone shows you who they are, we should believe them. violating administrative law, statutes, displaying lack of recognition for peers, for students, for patients, and for our regulators, with a cost to the public that is staggering. The best indicator of future performance is indeed past performance. While we cannot undo what has occurred to those who are before us for now for recognition and also for sanctions, we can and we must prioritize the public needs and patient safety. Administrative decrees may not change the heart, but they very well can restrain the heartless.
Dr. Gold, I'm going to object. The
In
board
your
accepting this
deliberations,
testimony
please consider
on
statutes
cases that-
provide,
Jack, please let the public comment continue. It's her right.
This is completely improper. This is
statute
not public
provides,
comment. This is
section
testimony.
801,
Very different.
411, the type of disciplinary action this board has option to also includes. Factor in number 6, any other matter that justice may require. Justice requires what we cannot have prevented before, that we do everything in our power to prevent further. Thank you.
Thank you, Mrs. Taylor. Next up, we have Mrs. Anita Ross. Ms. Anita Ross.
Good morning. Thank you for the opportunity to speak. This board is a consistent pattern of chronic failures, enforcement, and legal requirements as per their own rules of professional conduct. This is a short account of my personal tragedy. I filed my initial complaint the 20th of April, 2020 as a result of preventable death by my beloved dog Pirate under substandard and poor care by KC Farazano Singletary, with multiple violations by this vet, coupled with her dishonest and misleading exchange with both myself and my husband, led to an outcome that terminated Pirate at a young productive age. Dr. Farazano consistently and intentionally lied to us about the care he was receiving and the prognosis associated with her diagnoses. She stated it required an ultrasound, but claimed one was not available. However, evidence I found in the medical records showed that she did conduct one, and it was documented in the medical records that results indicated all 4 quadrants were negative for bleeding in his abdomen. This was a critical piece of information withheld intentionally from us, and it skewed our informed decision about his care. After we determined that Farazano was not placing Pirate's best welfare as a priority, we asked to have him released immediately to transport him to our regular veterinarian. She became defensive and unreasonable. 45 minutes passed as we were locked outside with no communications from the staff or her. Finally, after multiple attempts to gain communication, she approached us outside and stated that Pirate was bleeding to death and in fact dying as we speak. A fact that the official medical records proved false. Given her personal comments and informed information that we were given, we intentionally were misled and agreed to euthanasia. My experience working with the board's legal department under the direction of Brittany Sharkey has been fraught with deception, disregard for its own rules and regulations. Neither Farazano nor her attorney, Donald Farrell, responded to Mr. Dawkins' multiple requests as required by law. Mr. Dawkins documented multiple potential violations and investigating findings associated with my case. I also found in my own investigations that Farazano had committed other prior wrongdoings and resulted in fines and administrative penalties that were not listed on the bill. On the 4th of October, 2021, an informal conference was held via Zoom after 18 months. Our attorney was not permitted in the Zoom proceedings. After a very short period, Sharkey abruptly concluded the Zoom meeting without any discussion pertinent to the facts and findings. During the IC, Dr. Quillivan rather shockingly stated, quote, "There are no standards of care in veterinary medicine." Following this IC, Sharkey sent us an email 3 days later stating, quote, "The board found no violation of the rules of professional conduct, and yet multiple violations were present. The board has failed to provide the required information 801-208C rationales for dismissal." In conclusion, I would like to extend my appreciation to Dr. Gold's commitment to review my case. Ms. Sharkey's unprofessional and untruthful actions at ignoring my multiple emails is more proof of board failures and not holding those accountable. Dr. Gold, as an experienced expert witness, you know that multiple violations were made in Pirate's case, and no one is being held accountable for the poor and substandard care. For your own testimony in the Kaufman case, quote, "If you didn't document it, it didn't happen," unquote. You agreed to review my Pirate's case, but it will quote, "It will take some time," unquote, "and I will get back to you." It's been 258 days since you sent me that email, 1,379 days since Pirate's preventable death at the hands of Dr. Ferrazano, and no one's held accountable. Thank you.
Okay, that ends our public comment section of the agenda. Pursuant to Chapter 551071 of the Texas Government Code, this meeting of the Texas Board of Veterinary Medical Examiners will now go into executive session at 9:17 a.m. session in which no action was taken. We will now take a 5-minute recess. It's 10:31 a.m. We are returning from recess, and we will start by recognizing our Executive Director, Ms. Sharkey, for Director Reports.
Sorry about that. Thanks, everyone. Hi, Happy New Year. Welcome back from the holidays. It's been a very busy time around the agency. One of the things that we're most excited for right now are our staff changes. We've hired 5 additional investigators that started the first week of January. That fills out our enforcement division with 11 enforcement investigators. So we're really excited to have those folks up and running. They come to us with a wide variety of backgrounds and experiences. We've got folks from the veterinary community. We've got a former DEA agent, folks with law enforcement backgrounds. So they bring a really great, diverse set of experiences to the enforcement division, and we're excited to see what they do. And we're already seeing increased numbers in terms of complaint resolution, enforcement investigation. So that's going to be a real asset to the agency. In addition, we are still working with DIR and TDLR on a software procurement. We demoed a software the other last week. There's some follow-up questions and a follow-up demonstration. We're hoping that if this meets our needs that we can move forward with that and that procurement. So that is moving along, and that concludes my updates. Are there any questions?
Ms. Sharkey, can you expand upon our relationship with DIR and kind of what resources and support they're providing us in this process?
Sure. So we are using them to help us assist us with the procurement process. So we've gone through 2 different modes with them. They've got what's kind of an in-house contract with a company to do what's called an idea ticket, where you basically solicit and say, if we've got this amount of money, we're looking to do this kind of thing, what can you provide us? What does that solution look like? So we went that route and tested that out. Unfortunately, it was out of our budget. But then also they've put out a solicitation to their list of 500 plus vendors with our requirements. DIR conducted a needs assessment for us last spring, so we sent that out. Got responses back from vendors. So the one response we've got is the vendor that we are working with. So they've been really instrumental in helping us move this along, as has TDLR.
Thank you.
Would it be possible for you to go over exactly what that budget looks like?
Sure. So right now, we were appropriated $1.1 million as a capital budget project for that database, with $35,000 annually for maintenance, subscriptions, what have you. So we're really working within that $1.1 million budget and looking for something in that realm.
So does the software system you're looking at, does it meet all the requirements that we currently need?
So far on a first initial demonstration, yes. We've got some follow-up questions and a follow-up demonstration. Folks far smarter than me in the tech realm, especially from TDLR, have been very instrumental in helping us make sure that the back end needs are being met, as well as that kind of front end user experience. Because on the front end, I think it looks great, but they have a lot of other questions about what does the service level agreement look like? How do we escalate tickets and things like that? So we're working through that and resolving those questions.
Any other questions of Brittany? Okay, if not, Brittany, you can move on to your other reports.
Okay, great. Wendy.
Hello, everyone. I'm Wendy Womack. It's my first report, so it's nice to see you all. I did see you at the last board meeting when Wanda was still here. So today I'm reporting for the first quarter, which is September, October, November. So during that time period, we issued for new licenses, 100 new DVM licenses, 1 special, 1 EDP, which is the equine dental provider license, 110 LVT licenses, and 4 temporary licenses, for a total of 216 new licenses issued in the first quarter. The total agency license counts as of November 30th, the end of the quarter, were 9,270 DVM regular licenses, 53 DVM specials, 11 DVM temporaries, 2,270 LVT licenses, and 60 equine dental provider licenses, for a first quarter ending total of 11,664 licenses total. This concludes the licensing report. Are there any questions?
I have a question. So are these the current, that 11,664, is that the current? Because at one point we had a 13,000. Have we had we lost licensees, or is the rest of those numbers just haven't been counted yet?
Well, this was just the first quarter, and I would have to run another report to know how many are current to the present day.
Thank you.
If you'd like, I can do it, just send me an email.
Temporaries?
And I will say Wendy has, taken over the licensing division and really done a lot to help streamline and improve our processes. So she's been a real asset to the team. So we're excited to have her on board.
And I did want to note, this is the first quarter, September, October, November, when we don't have anyone graduating that much. So the whole crop of new licensees will be coming as they graduate.
So
Right,
those
I
are
was,
people moving to Texas, or
Which people?
like what you're reporting is people moving here and getting licenses, or
It could
if
be
it's
some
not
of
new
that.
students, or?
It could be, non-traditionally graduating students or people moving.
Any more questions?
Today I will be Mike Tacker. He is in the field training our new investigators and conducting on-site inspections with them. So for the period ending December 31st, enforcement has received 122 new complaints for this year. They've completed 147 investigations and conducted 502 inspections. So they are.
Is that on track with our expectations?
It is. So our new performance measure is to complete 1,600 inspections. So for that quarter, we are on track to hit that number by the end of the fiscal year.
We'd be at 2,000, the current pace. Is that correct?
So we'll be close to that. We'll be over that 1,600 number, but probably not excessively so.
Thank you.
Legal, Ms. Phelps.
Good morning, everyone. I'm Kelly Phelps in the new GC. This is my first board meeting, so wonderful to meet everyone. Presently in legal, we have 188 complaints pending. And so these numbers are projections. The number of cases pending board IC right now are 15. Pending board action, we have 45. Board orders pending signature, we have 26. We also have 10 cases on hold currently pending civil or criminal proceedings. We have 3 cases pending legal review, 45 cases pending staff conference. We also have 12 cases filed at SOA, although 9 of these are regarding the same respondent and are consolidated into one case. We also have 27 cases pending SOA filing and 5 cases pending cease and desist.
What was the number on pending SOA filings?
27.
Okay, thank you.
And after the board meeting, the projected complaints remaining are approximately 122. Any questions?
How many complaints are we getting a month? Do you have that?
So it's about between 40 and 50 complaints are received a month.
Thank you. So if we have 188 pending, we can do the math on the monthly. Thank you.
so if you don't mind, I want to back up one step back to, I don't know if this goes under licensing or other. As far as the temporary clinics go, when people have shot clinics, is it easy for them to get into the system and report their activity?
That would fall under temporary licensing for shot clinics if they're coming into the state.
No. They, when you're having a weekend clinic at the CVS or Tractor Supply or some other facility, and those are supposed to be registered. Is that something that we're doing easily?
So, yes, there's a form. So per our rules, there's a form on the website that everyone is required to fill out within 72 hours of the temporary clinic.
Right, and then if a temporary clinic occurs that has not been requested, or where that information hasn't been presented, what is the procedure for that?
So you would file a complaint just like any other complaint that comes to the board.
Right. And do we know what the normal sanction might be for something like that?
Without, I would not want to weigh into hypotheticals on this. It would, obviously be very dependent on what the board ultimately decided to go with, but it would fall into probably a staff conference kind of sanction because it's not a complaint requiring medical expertise, and so it would be up to staff to issue it along with the board to make that decision.
Okay, great, thank you.
And then up next, I am also Jared today. He is also out. So Jared is in our compliance department. Obviously, you're still very much hard at work. So far this fiscal year, they've granted 16 requests for hardship extensions for CEs. They've reviewed 179 fingerprints and followed up on 11 different CE audits. So they have been hard at work over there approving our CEs, fingerprints, and other compliance matters. Are there any questions? I would do my best to answer. All right, and finally, and now I get to hand it over to Candace, who is here and will save me from presenting.
Well, the finance division has been very busy, but we're holding steady. Not too much going on. We just ended the first quarter FY24. We're around 41% of the way through the year, and we've spent around 21% of the agency's budget. So I think we're doing pretty good as far as spending goes. Other than that, not much else to report. I have been selected to be a part of the 2024 class for the Texas Fiscal Officers Academy. So I'll be attending that. It's a 3-week class that will go on in February, March, and April. So that'll be a good benefit for our department. So
Congratulations.
thank you.
So the lag between the 20% to the 40% is predominantly the IT.
Correct.
Yeah.
Okay.
Yes.
But every other line item within the budget is on track.
Yes.
Okay.
And I will say, I will just plug, Candace was selected from a very competitive pool of applicants to be included in this class. So we're very excited for her and think it's going to be make her an even bigger asset to the team. So.
Congratulations.
Thank you.
Any other questions for Brittany or her team? Okay, hearing none, we're going to move on to board committee reports. Is there anybody who would like to provide an update on their committee?
Yep. The finance committee met, Brittany, Candace, and Raquel and I met for a very brief session, kind of covered the.
I was there.
You were not there.
I was there.
She was there.
Note to self, check for senile. I think I might need to up my medication. Sorry, Victoria. It's a very quick meeting and, we went over the budget and the issues that were discussed here. And we're happy with the report, so thanks.
All right, thank y'all for your work in that and keeping us on a straight line with our finance. Thank you. Any other committee reports? Okay, hearing none, we're going to.
I'm sorry, I have a question. I know it was mentioned there might be appointing on the LVT committee. Is that occurring today?
That's not occurring today. It's not on the agenda. We'll be
Okay, I didn't
addressing
see
that. As we work with TDLR, we'll address that.
Okay, thank you.
Okay, moving on to item number 6, discussion and possible recommendations to the Texas Commission of License Regulation regarding the proposal of rules to be posted in the Texas Register. I recognize Brittany Sharkey to present the 2 rule proposals.
Thank you, Dr. Gola. The first rule up for discussion today is Rule 573.83, which is price transparency for emergency care. This rule is required by a statute that was passed in the last legislative session that requires us to establish rules for price transparency in emergency situations before people agree to emergency care that clients are required to sign off and approve of those costs. So this is a rule that we are required by law to propose, and this version was worked out between the Rules Committee, Council with TDLR, and to get to this version.
Okay. And so this will go forward for publication and then comments. So this is a starting point, right?
Yes.
And I'm sure there will be many comments that we will receive, and then we will do our work from there, correct?
Yes.
How long do we have for public comment?
So it's a minimum of 30 days that it has to be posted, and then once we've hit that, it can be put on an agenda for a board meeting at any point after that, but usually, so the comment period ends up being longer than 30 days.
So we would expect this to come back to discussion at our next meeting.
Yes.
Okay, great. Any questions, board members?
One, can you please state the rule for?
Just read
Yeah,
it.
just, what does the rule say? What does it say?
Okay, so 573.83 price transparency for emergency care, section A. For purposes of this section, emergency care means medical care rendered to an ill or injured animal that in the reasoned opinion of the veterinarian has a life-threatening condition and immediate medical treatment is necessary to sustain life or alleviate or end suffering. Subsection B, after a reasonable opportunity to assess an animal's medical condition and before providing medical treatment, veterinarians must disclose to the owner or caretaker that that animal requires emergency care and treatment. Subsection C, the disclosure required by subsection B must contain 1, a description of the proposed treatments with reasonable options, if any, and 2, the estimated price of the proposed treatment options. Subsection D, if the animal's medical condition changes before continuing treatment, veterinarians must update the disclosures required by subsection C of this section. Subsection E, the person presenting an animal to the veterinarian for emergency care and treatment is presumed to be the owner or caretaker of that animal. Thank you.
Anything else? If not, we'll move on to Rule 577.15 fee schedule.
Yes. So with our additional appropriations, we are looking at a bit of a budget shortfall unless we raise our fees. And so we are proposing fee raises across the board to help cover these additional new appropriations to bring the agency in line with, I think, the robust regulatory community that veterinarians and LVTs and EDPs deserve. So this is a minimum, this amount proposed is the minimum required to cover our expenses. We were very judicious in running these calculations to make sure that we weren't raising anything beyond that what we needed to cover those costs. And we are looking really holistically at our budget to make sure that we're not spending in areas that we don't need to, cutting back where we can to minimize the impact to our licensees. You know, we know that these are challenging times and costs for everything have gone up, and this is unfortunately just part of where we are. We have not raised fees since 2018, so this has been 6 years coming. And this brings us in line with other medical providers in the state and across the country.
Ms. Sharkey, can you just kind of, looking at this and kind of watching the legislature and hearing the legislators talk at committee hearings and things, and looking at state appropriations, I was under the impression this wasn't gonna happen. So how do we get from A to C? Like what's the shortfall? Did the legislature not appropriate our special line items to the extent that it fulfilled where we were supposed to be? What's missing in the middle?
Sure. So all Article 8 agencies, so the occupational and regulatory agencies, are actually required to raise any of their own fees that they are appropriated. So there is no general revenue. We are required to raise our own fees and be a net zero cost to the state. So anytime we are asking for an exceptional item, it's usually with kind of the caveat and understanding that we are going to have to raise these fees. Now there are occasionally special exceptions granted, but we were not granted those exceptions. So in order to fund the agency, we have to raise those fees.
So once the implementation of the data IT system is in, that is not a one-time. The amount allocated for that system isn't just one time. Like there's going to be maintenance and additional costs to that, which y'all are in the process of looking at. Obviously, the legislature comes back next spring, but this idea that we go from here to meet up the budget shortfall for this fiscal cycle, potential of going down, do we anticipate understanding that we have an exceptional item, we have to do certain things to get where we need to be? Where does that take us then into the next fiscal year?
Sure. So our anticipation is that my hope is that this is a biennial increase only, that we do this for 2 years, and that once we've raised that $1.1 million, we can then drop the fees back down to cover the additional appropriations that we still have, but minus that capital budget project.
Because I think we weren't funding this agency where it needed to be.
Correct.
In previous bienniums. That's why we weren't able to provide investigators and do the services that the state and its growing sector needed us to do. So yes, there is some need for that, but as an agency, and all agencies are like that, we have to pay for that. but this might be part of a potential kind of up, down, just to get us where we need to be to provide the services that the state's asking for.
Correct. That's the hope, especially because this is, the bulk of the budget increase is a one-time capital project for the new database. And I, Ms. Whitehead, I would agree with your assessments that the agency was not asking for what we needed. We were not getting the resources we needed, and this budget represents a course correction where we've long needed to be.
Well, and I think too, like, we had to make up so much, right? And cost of doing business is, I mean, in my business, it's constantly increasing as well. So like, you know, steady increases are better than big jumps, but I think the service that we need to provide the public, it makes sense. Understanding, I would very much ask staff that while we're developing budget requests and working with LAR and the Legislative Budget Board, like, we really tell the story of what it takes to do what we're told we need to do. And if there's differences in where the final number ends up, we at least, you know, we did what we're supposed to do, and this is what we need to do it. So working with those that are stakeholders that pay those licensure fees, right? But we're also hamstringed by the legislative processes at play.
Correct. And so as we're starting to look at this for the next biennium and what that cycle looks like and what our requests are going to be, and obviously being very mindful of these additional appropriations and how successful we were at the legislature, and, you know, obviously adjusting our requests going forward.
Thank you.
Yeah, I'd just like to make a comment in regards to this, Brittany. You know, there's a lot of work that went into these numbers and how we calculated it, and a lot of discussion. I know this is going to create a lot of stakeholder conversation, and I think it's appropriate for that to happen. I just would like to reiterate what you said is that we have to start at this spot because statutorily, that is what is required of us by law. And of course, there's those that we can work with to help mitigate concerns, but this is where we're starting. And I look forward to the process as we go forward between now, public comments, and our next meeting coming up. So look forward to those comments coming in. So thank y'all for that.
Except one question about list of fees. Under less than 90 days length of a regular veterinary license is $280, but a regular veterinary license renewed on a timely matter is $340.
So is it okay if I'm late and then I can pay $280 instead of $340 when these numbers come in?
So I will say, for our purposes of running numbers, you don't, because we're trying to account for our budget, you don't want to count on folks being late. So adjustments were not made to these numbers, and that's something that we can do as part of the discussion in a re-proposal.
Okay.
Because
So
that does create.
This is just a baseline proposal.
Right.
And we'll be working, we'll be working on this
Yes.
as we get closer to looking at what our final budget will be based on the software system.
Correct. Correct. So we would anticipate raising the late fees commensurate with the main fees. But again, just for purposes of our calculation, this is the baseline to get us where we need to go, because in those calculations, you don't want to account and rely on folks not doing what they're supposed to be doing.
Yeah, but what my point is, I think that must have been an oversight because
Yes.
everything else in that column is adjusted. So less than 90 days delinquent, the first one, regular veterinary licenses, you would pay $280. The special veterinary license goes up from what you would normally pay. So the rest of the listings on that column, but not the regular veterinary license. See what I'm saying?
Right. So that's part of the discussion when we can because as we work on this after getting public comment and publication, we can work on adjusting those numbers.
Yeah, but that's got to be an oversight.
Yes, it is.
That really needs to be corrected before we do any publishing though, right? Because like Dr. Kreiner and I look at, it says there, if you renew on a normal time, you pay $340, but if you're 90 days late, you have to pay $280.
Is it safe to say that the 280 should be 280 times 1.74?
Yes, for the percentage.
And we can
increase.
make that reflection.
We can, and so y'all can, that is a motion that can be made today to make that change and propose it as is, so we stay on that timeline. Because unfortunately, the longer we wait, the more that increase goes up.
Does that require a motion, or is that just something that This is more of a staff.
No, we need to move
You would-
individually both of these for publication and vote on them. So
Okay.
we can move that with
The addendum.
the addendum.
Okay, great.
Any other questions about the fee schedule before we get to that?
Mr. Chairman, I move that we approve for publishing Rule 573.83 price transparency for emergency care.
I have a motion. Do I have a second?
Second,
It's been moved and seconded that we accept Rule 573.83 price transparency for emergency care. Is there any further discussion? Hearing none, all in favor, please say aye.
Aye.
Any opposed, nay?
Nay.
Okay, motion carries. Do I have a motion for Rule 57715?
I move that we adopt we approve for publication Rule 577.15, pending staff changes to the over 90-day delinquency at a rate of 1.7. Pending any amendments to my motions to my amendment.
Ms. Whitehead, I think the motion could be approved for publication with the changes noted in the discussion regarding fee amounts.
I move for publication, amending the changes from discussion to adequately reflect the change.
I have a motion to approve Rule 57715 with the changes of discussion. Do I have a second?
Second.
Okay, been moved and seconded. Any further discussion regarding that? Okay, hearing none, all in favor, please say aye.
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 Any opposed, please say nay.
Nay.
Okay, the motion carries, and we will have these two rules moved into publication. All right, next item up on the list is number 7, discussion regarding disciplinary practices for continuing education and violations. And I recognize once again, Ms. Sharkey for this item.
Thank you, Dr. Gullah. So because of our increased inspections, we are now conducting our CE audits in conjunction, in tandem with our random compliance inspections. That has raised the concern now of how we would like to handle and how the board wishes us to handle moving forward when we do find violations of our continuing education requirements. So currently the process right now is that if somebody is deficient or delinquent in their CE, and as a reminder, all licensees are required to keep records of their continuing education for a period of 4 years. If there's an issue and we do have some lapses due to some COVID emergency rulemaking that lapsed those requirements. But when we find somebody is deficient or delinquent on their CE, we usually give them 30 days to correct and provide us proof that they have before opening a disciplinary matter. However, I wanted to bring this to the board's attention and get input for what our how they feel the enforcement division should proceed with those cases.
So I'll make a couple of comments on this in regards to some experiences that the investigators are having, and what is occurring in some circumstances is that a licensee will renew their license. And if y'all are familiar with that process, there's a box that you have to check that says, yes, I am in compliance with my continuing education requirements for the previous year. And then you pay your fee and it moves forward. Some of those licensees, when inspected, then cannot produce the CE certificates that they said that they had when they renewed their license. The board investigators have then said, okay, give us 30 days and provide us those certificates. Many a times it's just they didn't have them on hand or they had them in a different folder. That's fine. But what they're finding is there's many that are checking the box but never got any CE. And because of COVID and the things, the investigators have been not as aggressive in terms of bringing charges against those folks. Say, okay, we'll get your CE in 30 days and then we'll move forward. I think now that we're past that COVID moment, I think we need to be a little bit more appropriate in terms of, you're going to sign a box that says you got your CE and you didn't, there should be punitive consequences for that. And in some cases, I'm talking to the investigators, there's been veterinarians that have had 2 or 3 years where they've checked the box and they didn't have CE. So the question is what type of punishment or how should we handle those cases is what I'd like to discuss. What's appropriate for that?
In addition to that, we've made CE, obtaining CE much easier. Correct. You can do it all online, so, used to you'd have to go to these conferences, spend a lot of money, spend a lot of time, a lot of effort. Now you can do them all online, so the whole process is easier. So I think we're to the point where we do need to kind of step it up.
What do we have under our authority when it, like,
We have the authority, it's in there,
It's-
so it just needs to be brought, the investigators need to bring it to the attention of staff, so it can either be a staff conference or an IC. I doubt it would be an IC unless it was really over the top. I think the staff conference would deal with that, and I do believe we have in our board rules sanctions for failure to get your CE. It's just it hasn't been implemented specifically because of COVID, but as Dr. Gola said, we're past that now.
And so this is simply a discussion, just to give, I think, some direction to from the board as kind of some direction to our team on how they wish to proceed. If, do you want to, we've been in a kind of a voluntary compliance space and letting folks work their way up and, make sure, give them that 30 days to correct any deficiencies. But if that's not the will of the board, then we can obviously go back and work on our policies to reflect
I
that.
think my opinion on this is if they got the CE and they just didn't have their certificates and they can produce them in 30 days, great. I get that makes sense. But if they actually didn't do the CE, giving them another 30 days after they check the box, I don't think that's acceptable. I think at that point, there should be some violation brought forward. And then, obviously they have the right to request an IC if they want to elevate it that far. I get it. There's extenuating circumstances we can discuss. But I think it's appropriate that if you check the box and you actually didn't get it, then there's got to be consequences.
Well, if you check the box, isn't that, and you haven't done it versus can't find it, isn't that a violation of some type of legal concern? Falsifying records?
We can look into that more, but I think that's definitely something that we can look into.
I think from a public perspective, CE is the one thing, especially as technology and medicine changes and practices change, is the one thing that helps ensure and protect the public from an education perspective. So I think we're very far out from COVID enough. I personally have way more stringent CE requirements on me. I wish I could check a box, but I think it's an easy thing to comply with, and we should be enforcing it.
Any further comments?
I have a
Okay,
comment.
great. Oh, yes, ma'am.
Is it possible that we change the way that the CE is reported? That way they're just not checking the box and moving forward, but they have to actually list the courses that they take for the CE, like we do at our CPA license?
So that would be an issue with our, hopefully moving forward into our new database where we would put more responsibility on the licensees to make sure that that information is uploaded into our database so that we could conduct those random audits just on the database and not through our compliance inspection program. So for right now, that's unfortunately the best we can do is checking the box, but our goal is to get to a place where it is uploaded.
Okay, thank you.
That's a great idea.
I do know in the state of Oklahoma, I'm licensed there, we do have to list each specific course that we take on our renewal.
Yes.
The other option is, if anyone is interested in the veterinary community, is to use the racetrack system that is supported by the AAVSB, which is where everyone gets their examinations and all their information is held otherwise.
The only other comment I'll make for those listening is just don't forget to get your every 2-year opioid CE. I think that's very important. We need to make sure we continue to do that as well. Okay, no further discussion. We're going to move on to agenda item number 8, consideration and possible recommendation to TDLR regarding contested cases heard before the State Office of Administrative Hearings. We have a process for this that we're going to follow, and I'm going to just kind of read this so that everybody understands our process. If anyone is appearing in person today to discuss these cases, we will call you up to address the board. The respondent's attorney will have the opportunity to be heard first, and then the prosecuting attorney. Please make sure to state your name clearly and who you represent. The respondent side will have 5 minutes, and then the prosecuting attorney will have 5 minutes rebuttal. And then the prosecuting will also have 3 minutes to close. And so we're gonna be timing those to keep things moving forward. And we're gonna start with that. So I'll call up first with item 1, which is Mark Lee and Dr. Copeman. I don't believe we have.
So we actually received, from Dr. Copeland's attorney, a request for a continuance, based on his, inability to travel here due to his wife's serious, condition. He also, tried to obtain alternate, counsel, but was unable to do so. So at this time, we would ask, if you would vote on the continuance to our next board meeting.
Okay, so we would need a motion whether to accept continuance or to deny it. Do I have one?
So moved to accept.
It's been moved to accept continuance of the CP 2371 and CP 21435/578-230227. Respondent Cody Copeman. Do I have a second?
Second.
Okay, any discussion by the board? Okay, hearing none, all in favor, please say aye.
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 Any opposed? Okay, motion carries. We will provide the continuance for the respondent case belonging to Cody Copeman. All right, moving on to item number 2, regards to Ashley Watts, respondent DVM. I'm going to first call up the respondent's attorney. Do we have that person present in the room?
Yes, and the notice I received said that the date for this was gonna be January 24th, which is tomorrow at 9 a.m.
Council, do we have?
I was not prepared to do this today.
So the notice does say Tuesday, January 24th at 9 a.m. Although in the text of the email, it says January 23rd, which is today, Tuesday. Our board agenda and dates have been posted for a long time. So they are obviously publicly available with the date of the board meeting, but the text of the letter says Tuesday, January 24th.
So in that communication, one says 23rd in the text, and then in that it says 24th. So it's a clerical error.
Correct.
Yes. And Dr. Gola, we can, if you could recess briefly to discuss this in executive session if you would like to.
Yes, I would like to discuss this in executive session. So with that being said, we are going to move
May I
into
respond
executive.
to that?
Excuse me?
May I respond to that first?
No, we're going to go into executive session.
Well, would you like to consider what I have to say about it in your executive session?
Okay, I'll grant it.
All right, thanks. So the notice, which is the letter, says January 24th. And the law says you're supposed to give me notice of the date of this hearing. Not the day of the week, the date. So I'm going by the date in the actual notice letter. I'm not required to go look up what's on the agenda. Because frankly, I can't figure out from the agenda. I don't memorize all these numbers. I assume since I got a notice for January the 24th, that I'm supposed to do this January 24th at 9 a.m. And
Duly noted. Thank you, Don. Okay, we're going to move into executive session. It is 11:09 a.m. the case for the respondent athlete Watts. Any comments from the board?
Dr. Gola, I move that we grant a continuance until the next called meeting of the board.
Can I have a motion to grant a continuance until the next called meeting of the board?
Second.
And a second. Any discussion? The only thing I'd like to say in regards to discussion is that was an error that occurred. This date, this meeting was posted. Apologize for the confusion on the date. And so we will reconvene and continue this at a future meeting date.
Thank you.
All right, so long as we get the motion to pass. So all in favor, please say aye.
Aye.
Any opposed? And motion carries and we grant it.
And I don't need to appear tomorrow at 9 a.m. Is that correct?
That is correct. Okay, moving forward on to board item number 9, agenda item number 9, consideration and possible recommendations to TDLR regarding approval of agreed orders. I recognize Ms. Phelps.
As noted on the agenda for agenda item 9, Dr. Skaggs has recused himself from voting on several of these orders. Do any other board members wish to recuse themselves for these cases?
Okay. All right, hearing none, is there a motion to recommend approval of the agreed orders on this agenda item?
I move that we approve the recommendations of agreed orders on this agenda item, subject to Dr. Skaggs' refusals.
Do I have a second?
Second.
Okay, having a motion and a second, is there any discussion? Hearing none, all of those in favor, please say aye.
Aye.
All opposed, please say nay. And the motion carries. Next, we're going to move to item number 10, and that is going to be consideration regarding dismissal of cases from informal conference. I recognize Ms. Phelps.
As noted on the agenda, Dr. Skaggs has recused himself from several cases. Do any other board members wish to be recused or pull any of these cases for executive session?
Hearing none, is there a motion to recommend approval of the cases for dismissal in this agenda item?
I move that we approve recommending that TDLR dismiss cases from informal conference as proposed in this agenda item, subject to Dr. Skaggs' recusal.
Have a motion. Do we have a second? Second. Is there any discussion on the proposed motion? Hearing none, all in favor, please say aye.
Aye.
All opposed, please say nay. The motion carries. Next, we move to agenda item number 11, consideration and possible recommendations regarding dismissal of cases from staff conference. I recognize Ms. Phelps.
Dr. Skaggs has recused himself from voting on one of these cases. Would any other board members wish to be recused or pull any of these cases for executive session?
Do I have a motion to recommend approval of these cases for dismissal in agenda item 11?
I approve that, or I move that we recommend these cases for dismissal, subject to Dr. Skaggs' refusal.
All in favor, please say aye. Do I have a second?
Second.
It's been moved and seconded. Is there any discussion for agenda item number 11? Hearing none, all in favor, please say aye.
Aye.
Opposed, nay. Motion carries. Agenda item 12, consideration and possible recommendation regarding dismissal of cases from medical review. Ms. Phelps.
As noted in the agenda, Dr. Skaggs has recused himself from voting on several of these cases. Do any other board members wish to be recused or pull any of these cases for executive session?
Hearing none, do I have a motion to recommend approval of the cases for dismissal in agenda item 12?
I move that we approve the cases for dismissal, subject to the recusals of Dr. Skaggs.
I have a motion. Do we have a second?
Second.
We have a motion and a second. Can Dr. Skaggs, is that appropriate for him to second it?
If he's recused.
I said second.
Oh, subject to, okay.
Let the record reflect that Ms. Olivier seconded the motion. With a motion and a second, it's open for discussion. Hearing none, all in favor, please say aye.
Aye.
Opposed, please say nay. The motion considering agenda item 12 passes. Okay, we're gonna move on to agenda item number 13. Do we have anyone on the board have future agenda items for discussion at our next board meeting? I would like to present one for an upcoming board meeting, and that has to do with regarding licenses associated with military transfers. I've had some conversation with some concern about the time that it takes for that to occur, so I'd like for us to talk about the process. Anybody else?
Dr. Gola,
Yes.
would this be an appropriate time to ask for further discussion with the TDLR about the appointing of the committee? To be,
No, we can sure put that on the agenda as well.
all right, thank you.
And I would assume that's for the EDP and the LVT committees, correct?
Speaking for LBT, yes,
Yes.
thank you.
Agenda item 14 is reserved for executive session. I see no need to go into executive session at this time, so we will move to, at this point, adjourn our, if there's no other comments by the board members, I move that we adjourn the meeting. Meeting is adjourned. The time is 11:28 a.m.